Hello there. As promised, update on the filing today, November 3rd, 2025 by the USDA. According to the criminal judges who have tried to order the United States government to unlawfully pull from other programs of which there is no legislative authority to do so, the United States government has said, no, you cannot do that, and we will not do that. In essence, is what they said. However, they are going to release half of November payments for those that are currently due for that. Nonetheless, it's not going to resolve once that money basically ends. There's no money. Meanwhile, there's going to be impeachment inquiry of these two judges who have suggested that they should criminally pull from funds of which there's no legislation. So we'll see what these judges are going to do. Are they going to even attempt to call in them as for contempt for refusing to break the law, as they have suggested? Yes, impeachment inquiries are coming. So this is that brief that was filed. Supplementary declaration of Patrick A. Penn, stating in essence that they are not going to release any money from funds that are for children. Of all things, they want them to steal money from children's funds that there's no legislation authority to do. It's so disgusting and demonic what they're trying to do. Anyways, but it didn't work. At the beginning of the fiscal year 2026, FNS had $6 billion in SNAP contingency funds. This is for the appropriation through 2026. In October 2025, they used $450 million from the contingency fund for SNAP state agencies, administrative expenses, and additional $300 million for nutrition assistance program block grants for the Puerto Rico and American Samoa, who are our territories. Per orders issued by the United States District Courts for the District of Massachusetts and Rhode Island, intends to deplete the SNAP contingency funds, which is for disasters, completely and provide reduced SNAP benefits for November. Even in the absence of an appropriation, states must by law continue to accept applications and conduct eligibility determinations. So states also must incur necessary expenses to recalculate and distribute these benefits. Accordingly, states continue to incur SAE necessary to operate SNAP. For November, the FNS will obligate $450 million for the contingency fund for SAE, an additional $150 million for NAP in Puerto Rico and American Samoa, of the value of 1 month of each block grant. The above will leave a total of $4.65 billion in the contingency fund for November SNAP benefits that will be obligated to cover 50% of eligible households' current allotments. This means that no funds will remain for the SNAP applicants certified in November disaster assistance, or as a cushion against the potential catastrophic consequences of shutting down SNAP entirely. The consideration of diverting Section 32 child nutrition funds or other funds is what they suggested that they should do, and they said in addition to routing the remaining SNAP contingency funds to partial November benefits, the USDA has carefully considered tapping that. And the bottom line is they're saying, no, that's not going to happen. USDA contemplated various factors, including the statutory mandate, evidencing clear congressional intent that Section 32 funds transferred to FNS be used for child nutrition programs. That's the legislative intent for that fund under this statute here, which are a group of programs that are distinct from SNAP in terms of legal authority, appropriation accounts, and operations. In addition, USDA considered the impact a transfer of the magnitude necessary to support SNAP would have on child nutrition programs, the likelihood or lack thereof, of Congress' ability to appropriate additional billions of dollars for child nutrition programs for fiscal year 2026 to make up the funding shortfall. Ultimately, the USDA has determined that Section 32 Child Nutrition Programs funds must remain available to protect full operation of child nutrition programs throughout the fiscal year, instead of being used for SNAP benefits. Section 32 Child Nutrition Programs are not a contingency fund for SNAP, period. Using billions of dollars from child nutrition for SNAP would leave an unprecedented gap in child nutrition funding that Congress has never had to fill with annual appropriations, and USDA cannot predict what Congress will do under these circumstances. The child nutrition programs, which include the National School Lunch, trying to steal school lunches from children, and breakfast programs, Summer Food Service Program, and Summer EBT, the Sunbucks, provide critical, nutritionally balanced meals and food assistance benefits to millions of children every day. These Democrats are literally trying to steal school lunches from children. Never let that be forgotten. Through the National School Lunch Program alone, approximately 29 million children per day receive nutritionally balanced, low-cost or no-cost lunches. So funding for the child nutrition program derives primarily from two sources: annual appropriations and funds transferred from the Section 32 account. So no, judges, they're not going to steal school lunches from little kids to give, because the Democrats are violating the law. By the way, they're violating the law, and I'm getting ready to show you exactly the law they're violating by trying to reverse OBA by withholding food from people of the country. Section 32 refers to a mandatory appropriation under 7 U.S.C. 612C and receives 30% of custom receipts on all imports from the prior calendar year. A large portion of those funds goes to the child nutrition programs. So to make them available for SNAP, the USDA would need to execute its discretionary authority under 7 U.S.C. 2257. Much of the public discussion of Section 32 misunderstands the funding. Congress has designated uses for Section 32 funds that do not include SNAP, and Congress purposefully avoided keeping any remainder and or unallocated Section 32 funds for general contingency purposes. While Section 32 funds are essential to child nutrition programs, they do not fully fund child nutrition programs. Congress must fund the remainder through annual appropriations. As an example of the dual funding streams for child nutrition programs, in fiscal year 2024, the total cost of child nutrition programs was approximately $33 billion. See consolidated appropriations. And don't forget, all the millions of undocumented kids in schools, yeah, they are getting that fund. So roughly $28.8 billion come from Section 32 funds and $4.5 billion come from annual appropriations. So for the fiscal year 25, the total cost of child nutrition programs was approximately $32.4 billion, with $22.4 billion coming from Section 32 funds and $10 billion come from annual appropriations. So for fiscal year 26, there is $25.2 billion in Section 32 funds derived from customs receipts, and approximately $23 billion was transferred to FNS for child nutrition programs. Stop trying to steal from the kids, Democrats. So C7 USC 612 CB1. So based on this budget request, this would mean Congress must still appropriate at least $13.2 billion for child nutrition programs in fiscal year 26 for a total of $36.27 billion. So, using the USDA's discretionary authority at 7 U.S.C. 2257 to transfer such a significant portion of child nutrition funds to top off SNAP contingency funds and issue full November SNAP allotments would leave child nutrition programs, which feed no fewer than 29 million children, with an unprecedented and significant shortfall. So, under current law that they're trying to violate, and they're going to be impeached for, another infusion of Section 32 tariff funds to child nutrition programs will not occur until fiscal year 27. So in other words, the $4 billion removed from child nutrition programs for 1 month of SNAP benefits would be a permanent loss to child nutrition programs for the entirety of their annual operations in fiscal year 26. So if Congress were to pass an annual appropriations act or continue resolution with the usual terms and conditions, the $4 billion gap would not be filled because Congress would not replenish the Section 32 portion with annual appropriations. Again, the Section 32 transfer is funded annually with custom receipts. So to make child nutrition programs whole for fiscal year 26, Congress would need to appropriate an additional $4 million in new budget authority. So in other words, instead of Congress appropriating the estimated $13.2 billion for child nutrition programs in fiscal year 26, Congress would need to appropriate more than $17 billion for child nutrition programs to continue funding the child nutrition programs at the level required to serve all eligible children. The pending continuing resolution makes no such additional appropriation. So while USDA transferred approximately $300 million in October to support the Special Supplemental Nutritional Program for Women, Infants, and Children, WIC. They are key differences. For example, the magnitude of the amounts $300 million for WIC in October 2025 versus $4 billion for SNAP is material consideration. So while USDA believes there are sufficient funds in the child nutrition programs to support WIC during these unprecedented circumstances, the agency does not believe the same is true for SNAP due to significant differences between the amount at issue. So USDA also believes a transfer of child nutrition program funding to support SNAP would further stray from the congressional intent. So while Congress has developed a statutory scheme for providing partial SNAP benefits and according to the courts provide contingency funds at the level is deemed sufficient, USDA would ignore those provisions while also threatening its ability to administer child nutrition programs if it were to repurpose funds that Congress explicitly intended to use only for child nutrition programs. A much smaller transfer for WIC does not undermine performance of the child nutrition programs and raises no such concerns. Amid this no-win quandary, and upon further consideration following the court's orders, USDA has determined that creating shortfall in child nutrition program funds to fund 1 month of SNAP benefits is an unacceptable risk, even considering the procedural difficulties with delivering a partial November SNAP payment, because shifting $4 billion to America's SNAP population merely shifts the problems to millions of American low-income children that receive their meals at school. The discretionary interchange authority at 7 U.S.C. 2257 allows transfers within the same bureau, division, or office. SNAP, Children Nutrition Programs, and WIC are in the same bureau, division, or office, namely the FNCS. So as explained, using Section 32 Child Nutrition Program funds jeopardizes those crucial programs, and WIC does not have funds to spare for SNAP. There are no other large blocks of funding, that is, funding not tied to yearly appropriations within FNCS that could be used to supplement SNAP. There are procedural difficulties that states will likely experience, which could affect the November SNAP benefits reaching households in a timely manner and in the correctly reduced amounts. And keep in mind that people do not everybody get their payments on the 1st. It is staggered throughout pretty much the whole month of November. So a lot of people are not even due yet. So before states begin making the novel system changes to implement the benefit reductions, USDA must notify states of the effective date of the reduction and by what percentage maximum SNAP allotments are to be reduced. USDA is prepared to issue such notice and revised issuance tables to state agencies on November 3rd. States will rely on the issuance tables to calculate the benefits due to each eligible household in their respective states. So on Friday, when Trump said that he's going to have his lawyers ask for clarification from these judges, well, basically, they have not given anything yet, and so they're saying here, okay, that you need to, point at something else with legislative intent, because, yeah, this is not happening. You're not going to make anybody take money from little kids. It's not going to happen. So, as is required by federal law, after receiving notice from FNS, state agencies must recode their eligibility systems to adjust for the reduced maximum allotments. The resulting reduced benefits amounts for certified SNAP households will be sent to the states. And keep in mind, they can only even give this partial payment by court order only, because it literally is not allowed by law, and it's subject to appeal because they're interpreting the law to say that, well, we say that you can use a fund that's specifically for disasters for an emergency that we declare that is the Democrats shutting down, basically refusing to give a clean CR, which is not proper and will be reversed on appeal. But nonetheless, currently, by releasing these funds, okay, they're only going to get a partial payment. But the demand to take money from elsewhere and the lies that they're sitting on funds that could be used, it's just a lie. And so, yeah, that's what they're doing. They're telling these judges that it cannot be done. So, in addition to adjusting eligibility and benefit issuance files to accommodate the reduction, states must notify SNAP households of reduction, as well as handling requests for fair hearings from SNAP households related to the reduction. As noted above, USDA will issue the appropriate notice and issuance tables today to comply with the court's order, and that is under USDA. And so here is the law that states what the Democrats are doing is actually unlawful. I'm going to show you. It is what is called the constructive impoundment of continuing and contingency appropriations, violates the Impoundment Control Act, ICA, 2 U.S.C. 683-684. While the ICA only governs funds made available by appropriation, The 2025 fiscal lap is not a complete exhaustion of appropriate authority. As of November 3rd, multiple categories of federal budget authority remain active and appropriated. So types of funding status, November 3rd, ICA applicability. The full year appropriations are not enacted, lapsed October 1st. So while certain discretionary programs are lapsed, the shutdown does not erase Congress' previously appropriated balances. These residual funds are available for obligation and cannot lawfully be withheld for political leverage, constructive impoundment via filibuster-induced inaction. SNAP Low-Income Contingency Fund 2, Section 20120. Congress permanently appropriated this fund to meet unanticipated program costs. States may draw upon it upon certifying need during funding interruptions. The current congressional filibuster prevents USDA from processing state certifications, functionally withholding those funds contrary to Section 6A4B. Any amount of budget authority proposed to be rescinded or withheld shall be made available for obligation unless Congress has approved such rescission. So public admissions by congressional leaders that suffering was intended to increase leverage constitute the requisite intentional impoundment satisfying ICA reviewability standards. The ICA's purpose confirms revealability. The ICA was enacted precisely to prevent the deliberate frustration of Democrats' fiscal intent. When legislative inaction operates to withhold already appropriated funds for political advantage, that inaction becomes functionally equivalent to executive impoundment. This court has recognized analogous doctrines in the Train versus City of New York. So statutory purpose cannot be nullified by political gamemanship. So Congress may not accomplish indirectly through procedural sabotage what it could not do directly by statute. That's in the Chadha case from 1983. So the ICA by its terms applies only to the executive branch. Ordinarily, congressional inaction during a lapse does not constitute impoundment. However, when Congress intentionally obstructs the release of already appropriated funds, contingency reserves, carryover accounts, or permanent appropriations, it performs the same constitutional offense that Train and Clinton forbid, nullifying enacted appropriations without bicameralism and presentment. So the Train versus City of New York case from 1975, the court held that once Congress has enacted an appropriation, no branch may frustrate the will of Congress, which is what the Democrats are doing by refusing to give a clean CR so they can tap into the funds that can be used during a shutdown. So Congress's own subsequent obstruction likewise frustrates Congress' will as expressed in its prior enactment. So the principle of this case in this argument is that neither branch may alter the operation of a duly enacted appropriation without bicameralism, presentment. Clinton versus City, New York, 1998 case. Clinton bars the president from canceling enacted spending, a refusal to fund non-passage of a CR as a functional cancellation by Congress. It is a reversed line item veto. So legislative actions altering legal rights must comply with full article procedure, INS versus Chadha case from 1983, a procedural blockade, which is the filibuster, that changes the legal effect of enacted appropriations constitutes a de facto legislative veto. So there's appropriated funds that can be given through a CR during a shutdown, and they're refusing to give the clean CR. Okay? So this filibuster, okay, is the very evil the Chadha case condemns. So in the Bowsher case, the court held that Congress cannot retain control over execution of the laws. Once Congress, and this is about the OBA law, that they are demanding that they're not going to allow any appropriations until they reverse this law. And this is why what they're doing on that is very unlawful. So here is the law that states just that. Once Congress makes its choice in enacting legislation, its participation ends. Period. It's over. OBA was passed, so Congress can thereafter control the execution of its enactment only indirectly by passing new legislation, of which they are not trying to do. They're just trying to withhold funds unless they reverse it. And that is unlawful. So Bowsher, 478 U.S. 73334. Under Bowsher versus Sinar, Congress's authority over execution ends once the funds are appropriated. So continued interference through refusal to permit expenditure by blocking CRs or reprogram authority constitutes unconstitutional control over execution. The precise evil Bowsher case forbids. Bowsher translates the execution limits of Train, the executive side, to congressional obstruction, the legislative side. So because contingency and carryover funds remain currently appropriated, congressional obstruction of their disbursement amounts to constructive impoundment. So there is an appropriation, fiscal year 2024 balances, contingency funds, and Congress is obstructing, Democrats specifically, their execution, which squarely triggers Bowsher and Train principles. This obstruction transforms Congress' appropriations power from a fiscal instrument into a post-enactment veto. The Constitution provides only one path to modify or repeal an existing statute: the passage of new legislation presented to the President for signature or veto. See INS versus Chadha. Conditioning the ordinary funding of government on the abandonment of existing law circumvents bicameralism and presentment no less than one House legislative veto condemned in Chadha. The result is a constitutional inversion. By withholding general appropriations until OBA is undone, Congress seeks to execute the laws. Democrats specifically seek to execute the laws it disapproves rather than make new ones. That violates the separation of powers at its core. See Clinton versus City of New York, the 1998 case. There is no provision in the Constitution that authorizes the President to enact, amend, or repeal statutes. And also what Congress is doing. What Clinton forbids the executive from doing, Bowsher forbids Congress from accomplishing through coercive non-funding, such as the Democrats are doing. As this court has recognized, the accumulation of all powers, legislative, executive, and judiciary, in the same hands may justly be pronounced the very definition of tyranny. The Federalist number 47 Madison quoted in Bowsher 478 U.S. at 722. By leveraging a shutdown to force statutory reversal of OBA, congressional leaders, Democrats, arrogate them to themselves the power to execute and suspend laws, converting fiscal brinkmanship into unconstitutional control over execution. So Congress can repeal OBA through new legislation, not by starving the government until it disappears. So once a law is enacted, their participation ends. That's the law. So the fact two judges failed to recognize their unlawful acts of Democrats and instead suggested criminally shifting funds from evasive somewhere fund absent legislative authority reeks time to impeach, and I'm going to show you that argument for their impeachment. Here is the Articles of Impeachment draft. Articles of Impeachment of Judges Talwani and McConnell for high crimes and misdemeanors, gross incompetency, and willful judicial misconduct. Whereas judges from the DDC in the Ninth Circuit presided over emergency shutdown litigation, Taxpayers United versus Schumer, whereas the United States filed a government brief November 1st citing Democratic leaders' admissions of using food and federal pay as political leverage. And I've already showed you the law that says what they've done is unlawful. So, forcing filibusters of a clean CR to force reversal of OBA, a duly enacted statute, Bowsher versus Sinner, prohibiting Congress from retaining execution control post-enactment, whereas these facts were undisputed on the record and binding judicial notice, whereas these judges, Talwani and McConnell, failed to recognize these acts as unlawful, instead issuing opinions that ignored Bowsher and Chadha, suggesting that the executive pull funds from somewhere, criminal encouragement of felony impoundment. Now, therefore, it be resolved. Article 1, gross incompetency and willful blindness to unlawful acts. Judge Talwani and McConnell demonstrated gross judicial incompetence by failing to recognize, despite government brief and public admissions, that Democratic refusal to pass a clean CR unless OBA is repealed constitutes unconstitutional execution control over a duly enacted law. Using food, SNAP, federal pay, and essential services as leverage is not negotiation. It is coercive suspension of law. Congress's participation ended upon OBA's enactment. Further control requires new legislation, not starvation. So instead of declaring these acts unlawful, the judges criminally conspired to ignore them and instead tried to act like there's money there to take from to try to protect these Democrats from actually starving people. So Article 2, criminal encouragement of felony impoundment. The judge's suggestion in dicta and bench remarks that the executive find funds somewhere to end the shutdown, and specifically, the other judge mentioned the Section 32, of which I have shared, absolutely cannot and will not be used, nor there is no legislative authority to do so. So, I see prohibition on unilateral withholding to a USC 684, Train v. City of New York 420 U.S. 35, 1975, barring executive fund shifting. This constitutes encouragement of felony impoundment, 18 U.S.C. Section 201. Abuse of judicial office to advocate lawbreaking. Violation of Canon 3A1 Code of Conduct for United States judges. A judge should be faithful to the law. Article 3, conspiracy to subvert separation of powers by ignoring Democratic leaders' admitted strategy, suffering equals leverage, and failing to apply Bowsher. The judges enable Congress to function as rogue executive, undermines Article 1, Section 7, bicameralism and presentment, converted judicial review into political cover for unconstitutional acts. This is not error, it is willful complicity. Relief sought, impeachment and removal from office, referral to Department of Justice for criminal investigation under 18 U.S.C. Section 201, 371 for conspiracy, and bar from future judicial appointment.